Hello everyone, I'm Professor Paul Carrier, and what I'd like to do today is to discuss the material for my Class 4 in Contracts 1. As you may recall, my hope is that you treat videos like this one as prequels to give you a little bit of a sense of what you're trying to pull out with regard to the most important things in the material for Class 4, or for any respective class. You can also use this video later as a review process, maybe leading up to the midterm examination or to the final. Okay, so we're here for Class 4. Remember, we are still in the formation phase. This is week 4, and we said formation would cover 7 weeks. The first week dealt with offer. The second week dealt with acceptance and the components of acceptance. The third week dealt with some special rules with regard to acceptance. For example, when that power is terminated. Right? Can the offeror reject the offer or revoke the offer? Can there be a lapse of time? If you remember, there are several ways that the offer can be closed off and then the offeree is no longer in the position to accept it. We also cover the mailbox rule of when a mailing or a clicking of an email is effective as the acceptance. Is it when you click the button or put it in the post? Or is it when the person has it, the offeror has that thing in his or her hand? Okay? We learned that the general rule is the former, not the latter. Today we're still on acceptance. This is the third week of coverage dealing with the acceptance element of formation. Today we are going to be working on one special area. We like to call it the Uniform Commercial Code Sale of Goods Battle of the Forms, which is a subset of what we like to also call gap fillers. I'll try to talk about gap fillers at the very end of this presentation. But what I'm doing right now is telling you basically about gap fillers. And here's the idea. Remember in week 2 and week 3, we discussed the fact that in the old days, an acceptance had to be the mirror image of the offer. The offeror was master of the offer, and the way that he or she expected acceptance had to be respected. Any failure would lead the wonky acceptance to be a rejection counteroffer. But remember how we discussed how maybe the standard shouldn't be quite so rigid. Responsive should be good enough. If you have an offer here and an acceptance that's really close, perhaps the parties intended for there still to be an agreement. And any piece that didn't quite match would be dealt with, but it wouldn't lead to a rejection counteroffer. It would lead to have the agreement set up, there's a formation here, and then we'll just fix the thing that's different or additional, right, but not have it act as a rejection. That, in other words, it would still be responsive, so long as we can take care of that additional or different term or set of terms. We can do that, we still have an agreement, and it's not a rejection. Okay? And that's what we're doing today. We're learning this in the context of the Florida Statute 672-207, which is Florida's adoption of Article 2, Battle of the Forms. I would have you know, even though you will probably only see this Battle of the Forms idea in the context of sale of goods, it's not impossible that a similar idea like responsive close enough, it's not necessarily unheard of that you could see that responsiveness also apply in a similar fashion in a common law case, such as dealing with the contract for services or a contract for employment. It'll be a little bit less precise perhaps, but it's not to say that responsive won't work as well in common law cases. I'll try to do a little graph with some paper in a little bit, but let me get through the explanation first, and let's see if with those two things together it'll congeal your understanding. We start with our 2207 sub 1, or Florida 672-2207 sub 1. What that says very simply is we don't like the mirror image rule. We prefer responsiveness. You can still keep it if you're very careful to keep the mirror image rule. But if you're not careful to keep it, we don't like you to use it, and we're going to go with responsive. Okay? In other words, something that adds an additional or a different term does not necessarily act as a rejection. In other words, it's responsive. It's not a mirror image problem. Subsection 2 has 2 different clauses. One deals with the situation where you have 2 non-merchants. It's still the sale of goods, but you have 2 or more non-merchants, or at least one side is a non-merchant. Okay, so if there's one non-merchant involved, in a set of agreements, this is the one you apply. The idea is this. If you have an additional term, like this has 3 terms and this adds a 4th, price, delivery, etc. This has price, delivery, etc., and it adds 4. We have to go to arbitration if there's ever a problem or dispute. Okay? Well, that 4th is an additional term. And if at least one is a non-merchant, that 4th is a proposal only. And so we have an agreement on 1, 2, and 3 because they match. And the 4th is only a proposal which falls out, which disappears, unless the offeror specifically agrees to it. If the offeror says nothing, that number 4 in the acceptance just falls out. There might be some implied term, a gap filler, that goes in. But number 4, because it's an additional term, would fail. All right? The other side, if there's one non-merchant, then the offeror does not have to accept additional terms. Then you get to the second clause, where both sides are all merchants. And we can define that later, but keep in mind this is a plural. Then, where you have an additional term, it's a proposal, but it automatically goes into the contract if it's not a big deal. Okay? If it's a big deal or you do something else, there's some exceptions to that. But let's say, price, parties, thing, ship by Friday. Or not even that. Wanted price, parties, due date, right? By end of month. Let's try that. Well, that still would be actually a different term. Price, parties, let's stop there. And the acceptance, or the purported acceptance comes back in. Price, parties, and we can't get it there before the end of the month. Okay, well, if you're near the end of the month and it's a warehouse buying extra stock or raw materials that it has a big stock of anyway, it just needs for the next month or two to replenish its warehouses, okay? Not a big deal. So that additional term, in that case, is not a big deal. So that would automatically become part of the agreement. So we'd have agreement on price, parties, and delivery by the end of the month, okay? Because it's not a big deal. If it were a big deal, there could be exception. But let me go back to the 3 exceptions in order of how they are presented in that sale of goods article. So again, if you have an additional term and it's not a big deal, it goes in if you're dealing with all sides as merchants. Unless, first, the offer requires the mirror image. It might say, we will not accept any additional terms. It's this way or no way. And that's a specific invocation of the mirror image rule, which, remember, the subsection 1 didn't like it, but said if you wanted to keep it, we'll let you, even though we don't like it. Well, if somebody says mirror image rule applies, don't have anything different in your purported acceptance, or we will treat it as a rejection. That's the rule. The second exception, if that additional term is a big deal, okay? If it's delivery 2 days later, chances are the offeror doesn't care. So it still is an additional term, but it could go in because it's not a big deal. What if it was a big deal? This one, the offer is, if you do something wrong and we're in breach, or even if you say we're in breach, you have to take the case to our local courts in this county, where we feel comfortable and where we have all of our lawyers and all of our employees. And the other side, that's actually the default, probably. The other side tries to throw in an arbitration clause. No, you must go to London, where we have all of our friends, and they like our business, not yours, and we're probably going to win. We're going through arbitration. I mean, arbitration clauses are much more subtle, but obviously the arbitration system is built to favor one side over the other. Okay, so some don't like it. And then when you see an arbitration clause or someone trying to stick it in as additional term, that's often, not always, treated as a material alteration, and it falls out. It's just too different. It's too nasty. So those things on which the parties agree, those could be the basis of the agreement. Or you could say there's not enough, and there's still a negotiation ability. But you could find enough commonality to form with enough definiteness of the right sufficient terms and go forward. But that additional term that's a material alteration, it's out. Further, the last one. If the other party who sees it, if the offeror sees the additional term and objects to it in a reasonable time, they call up, say, Ed, arbitration, no, we can't do that. Then it's also gone. So for those 3 exceptions, remember the idea. As between merchants, an additional term actually does go in automatically, right? Unless it fits one of these 3 exceptions. Different terms. If one says X and one says Y, most jurisdictions apply what we call the knockout rule. So X and Y knock out, and whatever's still there, like 1, 2, 3, 4, 5, X and Y are gone, 1, 2, 3, and 5 are there, there's our agreement right there. Okay, I'll do this graphically in a minute. And if there's a hole left by the knockout, then you gap fill with an implied term that the industry uses. So one says court, one says arbitration. They knock each other out. What comes back in? Well, what is the default if it's not included in the offer or the acceptance? It would probably be by default and by definition going to one of the courts in the jurisdiction of one of the two parties operating. And there are certain rules you'll learn in civil procedure to cover that. Well, again, quickly, the reason why we do this is to take things, acceptances that are just a little bit different, and try to save them so we have an agreement, which is probably what the parties intended, okay? That way, responsive is good enough rather than a rejection counteroffer. The rules I'm talking to you about now are default rules. Remember how you could maintain the mirror image rule if you specifically kept it? So if the offeror demands something to be accepted in a certain way, that is the rule, right? But where the offeror isn't so careful, it might be more flexible. Okay? Keep in mind that we teach this. This battle of the forms is a very sale of goods kind of a mechanism, but you might see something similar in common law. It's not like it can't happen in common law. Okay, I want to get to gap fillers in a minute, but first let's go through my little pictures. Let's just say we have a contract to purchase on the one side and a contract to sell on the other. You see how let's say this is the offer. No, wrong one. This is the offer. This is the acceptance. You see how the acceptance adds number 5? Well, that's an additional term. So if we have at least one non-merchant, that is a proposal only. And it disappears if the offeror does not agree to it. So if the offeror says, you know what, that's okay, I'll go for that, then you put it back in. But if the offeror doesn't agree, it falls out. Proposal only, okay? Now let's see if we can do the same where we're dealing with two merchants. So let me bring this back up. Now we're dealing with merchants again. And let me get this straight. Sorry about this. Same idea. Now we have this additional term, number 5. If you have both sides are merchants, then that number 5 actually automatically becomes part of the contract. Let's do that. Okay, so there it is. If you can see it. There. Unless it meets one of those 3 exceptions. There is a proviso clause saying you must accept by the mirror image, or it's a truly material alteration, a big deal, or the other party, the offeror, gives notice of objection within a reasonable time. And if that happens, it disappears. Okay, because the offeror is still the master of the offer. Now, finally and quickly, with the knockout rule, let's just say you've got, it doesn't even have to be merchants. If you've got parties that have like the similar, but one term says X alpha and the other is X beta, completely different. Like this is court and this is arbitration. Then what will happen is they will, and this is the general rule that I think applies in the majority of jurisdictions, they will knock themselves out. They disappear. And you just look at whatever default would be there. Okay, that's the knockout rule. They bounce out. Okay, let's see now. When you see a knockout or a hole, you will see perhaps a gap fill. We'll talk for a few terms, a few classes about gap fillers as well. Let me say one more thing. The 2207 has a subsection 3, and what that says is, let's just say that all this system didn't work. Subsection 1 didn't cover it, subsection 2 didn't cover it. So technically we don't have an agreement. But the parties have already done the shipping and sent the checks and got the insurance and have already performed a lot. Then we can cobble together an agreement from those items on which the offer and the acceptance agreed, plus gap fillers, plus how they performed. Because we need to cobble together something. They've gone too far to back out now.